Please be seated. We will hear argument in case number 230953, Ortiz versus Nelapatla.
Please the court. Ms. Jones will present argument for the petitioner. Petitioner has reserved 5 minutes for rebuttal.
Good morning, Your Honors, and may it please the court. Ms. Taisha Ortiz, the petitioner, is like many plaintiffs in Texas who suffered a relatively minor car accident, sustained minor injuries, and seeks a remedy for those minor injuries due to the negligence of the respondent that injured her. She filed a Section 18001 affidavit, 2 of them. The respondent filed 2 controverting affidavits, which did not controvert that 72% of her claimed medical expenses were reasonable and were necessary, and yet the jury awarded none of the uncontroverted 72% of her claimed medical damage.
So let me ask you, it seems that what you're really looking for is, what amounts to really a stipulation of the parties as to what the damages actually were, but because this procedural was not followed, then everything was kept out. So what is your legal authority for us to be able to do that?
Your Honor, the City of Keller case, which defines conclusive evidence, but I want to be clear.
Well, I'm talking about more statutory authority.
With respect to the affidavit, we acknowledge it is sufficient evidence only, and so we do not consider even uncontested, uncontroverted statements in the affidavit itself to be a stipulation. And that is consistent with the court's holding it in Ray Allstate, that the affidavit alone is only sufficient evidence. But the counter affidavit, which takes a position on behalf of the respondent about the reasonableness and the necessity of fees, specific numbers are provided by their experts, can be conclusive evidence, and it can be have the same effect as a stipulation.
And that's what I'm getting at. When where the two are aligned, then that seems to me that it is like a stipulation.
That's exactly right.
And so what is the authority for that?
Well, the legal authority is twofold. First, the definition of a statement by a party opponent in Rule 801E. And so the respondent's primary position on this point is that the counter affidavit cannot be construed as a statement by a party opponent. And so if the court rejects that premise, of course, as we contend it should, then the question becomes, is it conclusive under City of Keller versus Wilson? And we contend it is. The court there defined it said undisputed evidence may become conclusive evidence when a party admits it is true.
Well, in the case of affidavits in this context, if the counter affidavit disputes some or all, but not all charges, that says nothing about the charges that remain undisputed. It just simply says your evidence about reasonable necessity I'm counter affidavit. So it wouldn't seem like the counter affidavit is evidences to anything with respect to the parts of the chart of the medical bills that were undisputed.
That's exactly right, Your Honor, and that's why we claim that there is a opportunity under the statute for partial controversion and for affidavits to be admitted in part when they are not controverted. But as to the counter affidavit, it is a statement by a party opponent as to the amount of the plaintiff's damages that are reasonable and necessary. We have experts saying
no, it's to contest the plaintiff's statement as to what's reasonable, but it is not a concession that those medical expenses are conclusively proved. As you noted in Allstate, we said an affidavit like that is enough to get the medical bills in front of the jury, right? And then there can be a whole trial and people can still dispute those medical bills. So the counter affidavit just says, no, those bills can't get to the jury, but it doesn't say any, the bills that are contested in your position, but it doesn't say anything about the remainder of the bills being conclusively established.
Your Honor, the answer to that hinges on the definition of the statutory term claim. And the reason is Section 18001F requires the defendant to give reasonable notice of the factual basis on which they dispute, quote, the claim. And so we have to define what claim means. And there are 2 avenues the court can go. It can interpret the term broadly, or it can interpret the term narrowly. And the Parks dissent, actually out of the Dallas Court of Appeals, discusses these 2 options and does not take a position, but it's helpful. And if we interpret claim broadly, for example, the plaintiff's broad assertion of the right to payment, any amount that they're seeking, the total amount of damage that they seek, that's the broadest interpretation of claim. What that means is that the respondent can challenge only $1, a Band-Aid, of the plaintiff's claimed expense and counter the affidavit. And that's not what the legislature
Right,
intended.
and you seem to be taking the exact opposite position, which is if they don't contest every single dollar, then those amounts are conclusively established, which seems inconsistent with Allstate, where we said that the affidavit is some evidence of the reasonableness and necessity of those particular bills.
It's not inconsistent with Allstate because Allstate assumed there was no counter affidavit filed. In Allstate, the counter affidavit was struck for failure to give reasonable notice, and Justice Huddle wrote the opinion saying that reasonable notice is simply fair notice, and so that was incorrect. But then assumed that even if the counter affidavit had been properly excluded, the affidavit was only sufficient evidence, meaning it could be discussed in closing and evidence and argument at trial. But that does not address in any way the value of the counter affidavit, where the defendant says the reasonable and necessary amount of plaintiff's damages is $2,900 or $9,700 across the two counter affidavits, and gives no notice of any other basis on which the specific claims not mentioned in the counter affidavit are challenged. And so that's our argument, is for claim by claim controversy.
Doesn't Allstate also say that what gets said in the counter affidavits or not said in the counter affidavits doesn't constrain what gets admitted and argued at trial?
Not exactly, Your Honor. It simply reiterates the principle that it is the affidavit alone is sufficient evidence with or without a counter affidavit. And so, and frankly, this court has not considered whether the counter affidavit can be conclusive evidence and can be a statement by a party opponent. And at the very least, even if the court finds it's not conclusive, it should have been admitted and provides a basis to reverse and remand for a new trial at the very least. And so perhaps a path of less resistance is to analyze whether the counter affidavit is admissible at all as a statement by a party opponent, and if it should have been admitted, then to remand for a trial based on the admissible evidence. So the court doesn't need to reach the decision of whether it is conclusive evidence or a stipulation. But we contend it can under City of Keller versus Wilson, and that it should as a party admission under Rule 801. This court has talked about Rule 801E very frequently. The trial court below did not even cite or discuss Rule 801, did not talk about Rule 801B, which defines various exceptions to hearsay. And so I want to be clear, because one of the respondents' arguments is that the statute, that the exception to hearsay, Section 18001, does not provide for the admission of this counter affidavit. And we contend it does not need to, because it is not hearsay. And 18001 is an exception to hearsay. And so the exception to hearsay does not need to provide for non-hearsay. And statements by a party opponent are non-hearsay. And so because the trial court did not consider the degree to which the counter affidavit is non-hearsay, it erred and it abused its discretion. But I do want to address the primary statutory analysis before the court, which is the affidavit. What to do with the affidavit when it is controverted in part. And
as far as that, why shouldn't we look to the statute and all that it says to determine the context of claim? A claim, a party, so E says a party intending to controvert a claim reflected by the affidavit must serve a copy of the counter affidavit. And then F goes on to talk about what you do to controvert the claim, and it says that the counter affidavit, the person who's giving it is testifying in contravention of all or part of any of the matters contained in the initial affidavit. Should we look at that all or part statement as basically a fuller explanation of what the legislature means by a claim reflected by the affidavit?
that is our position, Your Honor. And in our bench exhibits, we've highlighted 5 statutory hooks that when you read the statute all together and put all of the words in context, support the notion that claim by claim controversion is required by the statute.
And by claim, it means a matter contained in the initial affidavit.
Well, it includes a matter contained in the initial affidavit, yes, but more precisely, we would define claim the way that this court has defined claim in other cases, looking at Black's Law Dictionary, and we would define it to mean the assertion of a right to payment. So we come back to the discussion we were having earlier of how broadly or how narrowly do we define the assertion of a right to payment. And
If we, to that end, if we have a holding that's narrower than what you're proposing, which is just that the affidavit is sufficient support for uncontested expenses to be submitted to the jury for the element of reasonableness and necessity, and nothing about the counter affidavit informs that, do you still win?
yes, Your
Is
Honor.
it still harmful error?
Yes, Your Honor, exclusion of the affidavit would still be harmful error because it caused the rendition of an improper judgment, and we can quantify that judgment to the penny, $12,724.50. So yes, the exclusion of the affidavit is still harmful, but to what I understand.
In other words, it's just the admission of, it's just a ruling on the admissibility of particular evidence, and it was harmful because this evidence was not admitted. Did you make efforts to redact the affidavit?
Your Honor, not exactly, but the argument was made that it should be admitted in part. And because the court rejected that argument, the trial lawyers never got to the practicality of what that might look like. That is one way that courts have handled this. The Moreno versus Ingram out of Dallas contemplates a redacted affidavit. Also, 18002B-2 talks about when charges are inadmissible, they should not be considered or they should not be provided to the jury. And so that language contemplates partial admission of affidavits. So Justice Busby, back to your question, reading the statute in context, that is part of the statute's context, is that it says where some charges are inadmissible, they should not be provided to the jury or they should be excluded. And so that solves the problem. When we read all of the language together, it does show that a claim-by-claim controversion is required. And I want to complete my answer to your question, which is, how do we define claim and what does it include? And we would contend that it defines a charge for a service, both of which are terms, nouns used in the statute. And so where a claim is comprised of a charge for a service and the affidavit requires reasonable notice of a challenge to a claim, then that means that the respondent or the defendant has to provide a claim-by-claim controversion of the itemized medical bill that is submitted by the plaintiff. And of course, the statute requires the bill to be itemized so that the defendant can undertake exactly that analysis, and that's what they did here. They complain about how impractical and how difficult this will be, but if you look at their counter affidavits, that's exactly what they do. They provide claim-by-claim controversion where they go CPT code by CPT code and say that's unreasonable, that's unnecessary, but the rest of it we agree with. And
so the life sciences affidavit did that with respect, the counter affidavit did that with respect to each one of the life sciences affidavit, but with respect to the synergy affidavit, the counter affidavit didn't, right? So why wouldn't one reasonable solution to this be to say, well, with respect to the life science affidavit, that is all out, none of that comes in. The uncontested part of the synergy affidavit does come in, that could justify something that a jury did, and the rest of it just needs to be presented by expert testimony. Why wouldn't that be a sensible solution?
Perhaps it would be, Your Honor, but we contend both affidavits do provide a claim-by-claim controversion. So Goutreau, the defense expert, who is the, I believe she's the life sciences expert. Yes, she is. Life sciences is the Goutreau. And what she does is she says, on these particular charges, which she identifies, they are unreasonable and should have been billed at 50% of the billed amount.
Yeah, so all of those, I think that that's fully controverted.
We would disagree, Your Honor, where she's saying that a portion of the charge is not controverted. And so she has not controverted both the charge for the service and put them together and said this is she's agreed practically that 50% of that is reasonable and is necessary.
So I hear what you're saying, but I'm saying with respect to each, even if we accept your view of what the claims are, item by item, each of those has now been addressed by the counter affidavit. So one solution would be to say, all right, that just means that it goes to the jury. With respect, however, to I think this is at least partially a friendly question, at least with respect to the life sciences, the synergy affidavit, I don't think that happens.
I understand your
part
question
of that,
now.
and that makes me wonder if maybe a new trial would be correct, that part of the synergy affidavit does go to the jury and the rest of it just has to be done?
I think that's right, Your Honor. And so if all we're looking at is the affidavit, I think we would have to agree with you that a controversion of a specific claim has controverted the claim. So then the question would become, if you reach the counter affidavit issue, is the stipulation that half of that amount, half of each of those contested claims, is that admissible as evidence against a party opponent? And so those are two separate analyses under the affidavit and the counter affidavit. And I see that I'm running very short on time, so I will reserve for rebuttal. Thank you.
Any further questions? Thank you, counsel. We'll hear from the respondent.
May it please the court, Mr. Northrop will present argument for the respondent.
May it please the court. This case is not about whether the plaintiff can abandon some portion of her damages. That's clear that she can. The case is about whether she can do that 2 years after counter affidavits were filed when the case is called to trial and effectively snap back her 18001 affidavits so that they once again become sufficient evidence of reasonable and necessary medical expenses to support a jury verdict. The approach that the petitioner is advocating for in this case is not contemplated by 18001, and in fact is contrary to the language of 18001. Fashioning a judicial carve-out, I think, risks destabilizing a very well-established procedure. This statute has been in effect for over 45 years and has worked pretty well, but today we're told that there's a hidden interpretation that has only come to the forefront.
Is that really the case? Because often these medical bills are the subject of pretrial, and everybody gets together and says, oh, these bills are countered, okay, doesn't come in, and these bills are not, and so your affidavit's sufficient for these, and at the end of the day, those are the bills that get submitted to the jury. I mean, it's not. It hasn't, in practice, it hasn't been
So you asked a good question.
An all or nothing decision, I think, which is what you're advocating for.
I think what I'm advocating for is to apply the statute as it's written. I know that in practice, and this is something I've learned in preparing for this, there are all sorts of scenarios that are worked out, and in fact, sometimes parties agree to submit competing affidavits and counter affidavits. Those are all just agreements that are outside the text of the statute. But what's being asked here...
Where does the text of the statute say that anything is inadmissible?
The text of the statute specifically says in 18001B that unless a controverting affidavit is served as provided by this section,
It's sufficient evidence,
yes,
unless the affidavit is served. But it doesn't say that if a controverting affidavit is served controverting part of the charges, the affidavit is inadmissible. I don't see the word inadmissible anywhere in 18001.
It does not say that. So this is the codified version of what was originally passed, and it was a non-substantive codification. And if you look at the legislative history, it's much clearer than the statute reads today. The pre-codified version said, and this is also in the amicus brief from the TADC, that when a counter affidavit is so filed and served, the subsection A of this section 1, which deals with the original affidavit, shall thereafter have no force or effect at the trial of the case. So
the sufficient evidence part shall have no force and effect is what you're saying?
That's what I'm saying.
But it still doesn't talk about admissibility.
It does not talk about admissibility. I would also refer, in response to your question, Justice Busby, to the Justice Huddle's opinion in Allstate, where she's talking about the counter affidavits. And in connection with the counter affidavits, she makes the point that counter affidavits are not meant to be admissible. And I think that's important here, both for the affidavits and the counter affidavits. But the idea here is, this is why it shouldn't be admitted here, is because The counter affidavit is sort of like, I guess I would analogize to the medical affidavits where you have to have an affidavit of an expert before you can even move forward with the case. That's sort of what this is. It's not intended to go before the jury. It's intended to go to the judge to the extent it's challenged. But once it's filed, all bets are off. The predicate language in 18001B is, and it's always been used that way, that as soon as the controverting affidavit is filed, then the section 18001 procedure is no longer available as to the affidavit that has been controverted.
Wouldn't it be extremely foolish for a counter affidavit to go into any great detail? You just find one thing that's unreasonable from the affidavit and you're done.
So there is, I think that's a fair question, and I think that, so there's a lot of things that go on, and this is another reason I think this is a bad case, or it's bad to try to do this in a judicial proceeding. I think it's better for the legislature to solve to the extent this needs solving, is behind the scenes there's a lot of cost-benefit analysis that goes on both sides. On the defense side, you have to decide, do I want to pay somebody to look at the affidavits, and maybe the ultimate benefit is I pay somebody $2,000 to look at it, and I wind up challenging $1,000 worth of expenses. Well, there's a loss there. And if you don't do it, then there's also
Why
a
is that a
possibility.
loss? I mean, it seems like if your theory is that that's enough to get rid of the entire affidavit, that seems like a win.
Well, it might be a win, but ultimately.
In fact, you then say to the expert,
ultimately,
and you stop. As soon as you find something that you can say is unreasonable, stop the clock.
Right.
Your billable rate is zero from that point on.
Well, I don't think that's exactly what happens, but I think.
But why wouldn't it? If your theory is right, I guess is what I'm trying to figure out.
So
maybe you're saying, yes, that's exactly right, but that's the way the statute is written. Is that your point?
Yes, that's what happens.
And your friend referenced 18.002B-2, which does, Justice Buzz was asking about reference to when something is not admissible, and it does use that phrase, is not admissible, and it's talking about a charge that is not recoverable. The reference to that charge is not admissible, which seems to me that we do have statutory text, part of the statute as a whole, that implicates the legislature's understanding that we're looking at this more granularly and that we're looking to individual charges. And why would that not say to us that given that text, I'll put it this way, I would accept your reading of the statute only if it is the only possible reading of the statute.
Right.
And I think that
So-
B2 gives me a pretty good reason to not think that
So
that extremely rigid understanding of the statute cannot be the only reason.
So B2 is an add-on. It came about in response to this court's opinion in the Escobedo versus Haygood case. And it was intended to deal with those expenses that are billed but not recoverable. And so what happens a lot of times with these affidavits is that you go to your medical providers, you get the affidavits, there may even be insurance in the background. What they do is they print out this long list of charges, things that are sometimes not recoverable. And so 18001B2, I'm sorry, 18002 B2 is dealing with that set of expenses that may show up in the itemized charges, and they should never go to the jury. So they're redacted because there's something not recoverable. We're not talking about expenses here that are not recoverable. In fact, that plaintiff is wanting to recover those, and they may in fact be recoverable, and a jury, that goes to the jury to decide.
But it didn't say that the affidavit, suddenly you put something in here that's controverted. One way you can controvert it is by the counter affidavit. Another way would be, as you're describing, it's just not recoverable, maybe as a matter of law, but it's still looking them at the individual level.
You're right.
And that, Escobedo, that's paid or incurred, so a portion of them may be recoverable, right?
And those would go to the jury.
Insurance rate.
Right. So
And so that really sort of indicates that not only is a particular charge at issue, but the amount charged is at issue for a particular charge.
Yes.
And it's rare for the legislature to promulgate a form, which they
It
did in
is,
this
and
case.
it's important that the B2 language is in it's not in 18001, it's in 18002, which deals with the form of the affidavit. And the language in 18002 talks about charges, itemized charges, which is a little different than the language in 18001, which deals with claims. So the legislature...
But there's only one form. There's not a different form for 18001, and the legislature said, here's the form of the counter affidavit.
Right.
Use this form
So-
to try to avoid sort of disputes about how this should work.
Agreed, Your Honor. And so what happens is that when you get a form that includes those charges that Escobedo versus Haygood says those are not recoverable charges, those are behind the affidavit. And 18001 is talking about, it actually uses language that says that the affidavit reflects a charge that is not recoverable. I'm sorry, that if a party intending to controvert a claim reflected in an affidavit.
And why doesn't F tell us what that means? Because if you look at, so your point is, well, 18001B says if you serve a controverting affidavit as provided by this section, you can't consider the original affidavit at all, but it says as provided by this section. So we've got to go look and see in E and F and other places what it means to serve a controverting affidavit and what it's controverting, right? And so you're pointing us to the language in E that says a claim reflected by the affidavit, but doesn't F then tell us what it means to controvert the claim reflected by the affidavit? That's in the first sentence. And then the second sentence tells us that the expert is testifying in contravention of all or part of any of the matters contained in the initial affidavit. So why shouldn't we read that all or part of any of the matters contained in the initial affidavit to be the legislature's understanding of what a claim is in this context?
I think it is doing that, Your
Okay,
Honor.
so if that's right, and you're controverting part of the matters contained in the initial affidavit, then you're not controverting the claim as to any of the other matters that are contained in the affidavit, that the counter affidavit is not addressing.
No, I don't read it that way, Your Honor. I think if you controvert all or part of a claim reflected in the affidavit, then you have filed a counter affidavit that complies with subsection F.
How are you giving reasonable notice of the basis on which you're controverting the uncontroverted the charges that aren't being controverted?
We are giving reasonable notice of the part that you're controverting, but as long as that it's a compliant affidavit, then under B it precludes the affidavits from having sufficiency of the evidence to support a jury verdict. And
I'm just having trouble reading F that way, because B says you look at the rest of the statute to decide what constitutes a controverting affidavit, and F seems to say a controverting affidavit can be in contravention of only part of the matters contained in the initial affidavit.
right, you can controvert a part of a claim reflected in the affidavit, and at that point you have a valid controverting affidavit, and under B, that valid controverting affidavit precludes the filed affidavits from having any force and effect using the original language that is passed.
Suppose there were 10 items that were charges, let's say, that together form the claim. Could you, in theory, have 10 affidavits that each responded to one of the 10 charges?
So I think that would theoretically be an in-run around this.
Well, we got to follow the statute as it's written, right? I mean,
Right.
So if that happens, then you negate one of them with a counter affidavit, but the other 9 come in.
Yes.
Okay, so really what we're talking about is the effect of this court's decision is either going to say to plaintiffs, now you have to file 50 affidavits if there are 50 charges, or we're going to say you can file just the one, and then if you file a counter affidavit that gets rid of the one, then that one's out and we'll deal with the other 49. That's the effect, right?
I think, yes, Your Honor. I think that's the way this has been read and the way it's been applied for 45 years. And
Do we have cases with 50 affidavits?
I honestly, I don't know, Your Honor, whether there are cases where...
I'm just doubtful that it's been applied in that way for all of these years, and on the theory that if you get rid of $1 out of $1 million in charges, that the whole thing is gone. We would have something that's more like what I'm describing. If
I don't
that really were the
think, I don't
way
think you
it's
see anything
applied.
that extreme happening, Your Honor. I think, so one of the things...
No, what happens is, the affidavit is the affidavit, there's medical bills attached to the affidavit, and the one that's contested gets pulled out. That's what happens.
So, but then the plaintiff is required to bring an expert to trial that is then subject to cross-examination.
As to the bill that's redacted, or the charge that's redacted or pulled out.
Well, as the entire...
Yeah, your position is that, no, none of the bills go in, and the affidavit is just insufficient as to all of them, right?
Yes, that the plaintiff would be required to bring an expert to trial at that point to prove up those expenses.
So under your theory, why wouldn't a plaintiff in the next case put as the first line of the affidavit, each charge in this, the attached bill shall be considered to be supported by a separate affidavit?
I think that would be one approach on the plaintiff's side to doing it. I'm not sure anybody's tried that approach, but...
Well, it seems like we get to the same place.
Right, well,
Is that really necessary?
I don't know. So, Your Honor, this is the situation, and part of the reason I think that this is a bad venue to try to resolve a case where plaintiff showed up at trial without an expert and necessity became the mother of invention, and suddenly we have this new interpretation. But I think...
Isn't part of the answer that the sufficiency of the uncontroverted parts of the affidavit to establish whatever they want to establish becomes uncontested if you don't bother with it as the defense? And so in practice, why would you... There are a lot of situations where you just wouldn't bother arguing that they haven't proven the uncontroverted portions of the affidavit with admissible evidence.
That does happen sometimes, and I think that's, again, trying to promulgate from the bench, I guess, a rule that applies across the board, I think, is going to sort of disrupt the entire practice.
How would it? That kind of goes back to what I started with. I mean, I don't see how it would disrupt everything.
So I get back to the whole cost-benefit analysis that's going on either side of the affidavit, counter-affidavit. Should we, spend the money, or should we use that money to perhaps settle the case? Then on the plaintiff's side, do I spend the money to bring an expert to trial, or is there some other alternative to getting this case settled before trial without having to go hire the expert to bring to trial? And I mean, it's just the dynamics of the entire thing, and every case is different. Is it a large damage case? Is it a small damage case? Are there multiple providers? Or are there one provider? It's all different. One thing I do want to mention, I guess, just briefly before we close, is that it's a lurking issue in this case in terms of the disposition. The plaintiff's brief on the merits asks for a rendition. Rendition is not the appropriate remedy here. Opposing counsel, I think today has sort of indicated remand is the proper remedy. The petition for review seeks a new trial on damages only. That's not a proper remedy in this case either. And so this brings me back to this court's opinion in Stevens versus National Education Center 2000 case, where it's a petition denied case, where the court denied the petition because relief was being requested that the court could not grant.
There are also cases saying that you can grant, as long as they ask for the greater relief, you can grant lesser relief if that's what the rules provide for.
And you're right, Your Honor. And your opinion in the Garza case, when you were on the 14th, referred to the interpretations that courts have applied to the Stevens case as sort of a rendition or bust strategy, that I either want this, and if I can't have it, nothing, and that the courts have concluded that, well, if that's the situation, then perhaps the erroneous ruling has to stand to the extent it is erroneous. But I think the Stevens case is sort of lurking out there. I tried to look at exactly behind the scenes on what was requested. I couldn't see where NEC, the petitioner in that case, had requested sort of the relief that's described in the per curiam opinion, but that's one of those cases that was destroyed by the ransomware attack, and so the briefing that's online is a little bit fuzzy, but.
Counsel, we haven't talked much about the admission of the counter affidavits.
Yes.
And I understand there are some problems from your briefing. I wanted to just ask you if you can tell me what you make of 18.001G, which begins the party offering the counter affidavit in evidence.
So,
which seems different, to at least contemplate it being part of the evidence as opposed to just something that's there to destroy the affidavit.
yeah, that's a curious phrasing, but I think what it's referencing is exactly what Justice Huddle's opinion is talking about, is that we're not really talking about it going into evidence. That's not the
literally
purpose of it.
says
Not in
offering it
evidence
in
for
evidence.
a jury, because sometimes you have proceedings where you're presenting evidence, but it's not in front of a jury, it's to the judge, and the judge is making some decision. And I think that's what that's contemplating, is that it is not contemplated to be an admissible affidavit in front of a jury.
Your friend in opposition in the reply brief cites our Reed Road opinion, and since you haven't gotten an opportunity to respond to that, they cite Reed Road to say that the counter affidavit is not hearsay because it's an adopted statement.
So I think if you look at Reed, I think it's critical that you look at the fact that Reed says we are not going to decide that in all situations where you have an expert hired and designated, that's always admissible. In that case, the court said it's admissible because the expert was testifying as to a appraisal number, and this was in the administrative phase of a condemnation case. And then when the case gets appealed and goes to trial, the question is, does that expert's opinion as to valuation, is that an admission or is it not hearsay, I guess was the question under the rules. And the court said in this context, because they had essentially adopted that number. Now, in terms of the counter affidavit in this case, there is not an adoption per se of the uncontested parts. The purpose of the counter affidavit is to challenge portions of the affidavits.
Any further questions? Thank you, Mr. Northrop. Ms. Jones, you have 5 minutes.
Thank you, Your Honor. May it please the court. 4 points on rebuttal. I want to begin with the easy part, which is the remedy. This court is going to get it right. We pled for broad relief in our brief, and Justice Busby, you asked, can the court grant lesser relief than what we have asked for as long as we've asked for the broad relief? The answer to that question is yes. The respondent has never challenged our remedy in their brief. They've never briefed this at all. They've never raised any argument about this. So an argument on this point from them is waived, and this court is going to get it right and has full license based on the way we briefed this case to get it right and to afford the petitioner whatever remedy may be appropriate. That's my first point. My second point is that the respondent's only textual argument in this case looks at subsection B of the statute, which begins with the language, unless a controverting affidavit is filed. And so we know, based on that textual preface, that subsection B only deals with the situation where there is no controverting counter affidavit filed. So it does not tell us at all what happens where there is a controverting counter affidavit that challenges claims only in part or only some of the claims. It simply does not answer the question. And that is so important because it is their only textual argument. And under their argument, the statute would be rendered meaningless if all that is necessary is for a defendant to challenge $1 of a plaintiff's claim for medical expense to exclude the affidavit in full. That would render the statute meaningless, which this court knows it cannot do.
Why would it be meaningless? Why wouldn't you just get back to the status quo that the plaintiff has to put up an expert and go and make the costly proof of all of the different bills? Justice
Sullivan, I say it would be meaningless because it would not serve what the legislature has said is both the purpose and legislative intent, which are distinct, I acknowledge, behind the statute, which is to streamline this burden of proof. And so where all that is necessary is the gamesmanship of a $1 counter affidavit, that purpose of the legislature is frustrated. And so for that reason, we contend the statute would be rendered meaningless. But I also want to address their argument about the history of the statute. They argue that the 1979 version of the statute was codified with language that says, essentially, the initial affidavit, it shall have no effect. It shall be as if the statute does not exist if a counter affidavit is filed. I want to cite this court to its opinion in Fleming Foods of Texas versus Rylander, which discussed what happens when the legislature enacts a new version of a statute and says it intends for no substantive change to occur. This court said there, citizens, lawyers who represent them, judges, and members of the legislature should not be required to research the law that preceded every codification. We must be able to accept and to rely upon the words written by the legislature if the words are clear and do not produce absurd results. So my point is, where there actually has been a substantive change in the law, and there has been here, the court looks at the new law. And so the Fleming Foods case is the response to the reliance on the historical version of the statute. My final point is that nothing in the statute says the counter affidavit is inadmissible. Subsection G does contemplate that it may be admissible. I want to cite this court to Chapter 74, which explicitly says that expert reports are not admissible once that procedural burden shifting of Chapter 74 is satisfied. And so we don't have that language here, and we presume under this court's precedent that the legislature intentionally omitted that type of language here. And so nothing says it's inadmissible. We contend 801E says it's non-hearsay, and so we don't even need to look at 18001, which is an exception to hearsay. So for all of these reasons, we ask the court to reverse. We ask the court to hold that the affidavit is admissible unless each claim is controverted. And then
allowing the counter affidavit in strikes me as having the consequence of doing some violence to the structure of this statute. I mean, the only reason that you do this counter affidavit is because the legislature's created this streamlined ability to try to get certain things done without having to have all the testimony. But then if they do that, and so now we're going to have that, but then you can actually put the counter affidavit right there back in front of the jury. You've eliminated, so maybe to use your words, you've rendered the statute meaningless, almost.
Your Honor, I see my time is about to expire. May I answer? No, Your Honor, we're not rendering the statute meaningless by contending that the counter affidavit may contain concessions that are conclusive evidence against the respondent. We're simply interpreting City of Keller, which says that undisputed issues do not need to go before the jury. And it would be
Would you agree that you at least would have to strike out anything that says, look, the affidavit says that it's $10,000 is reasonable, that can't be right, it's got to be this. You'd at least have to strike out the part that says that the affidavit says it's $10,000. If that's the case, then you're just now getting the affidavit before the jury, and it's an end run around that, right?
Well, what we're asking for is that if the plaintiff, we're asking for a choice. The plaintiff says my number is X. The defendant says no, the number should be Y. They've taken a position. Okay. The plaintiff should have a choice to either pay to bring experts or to accept Y. And so all we're asking for is that choice. And the counter affidavit, where it's not precluded from being admitted by the statute and where it is non-hearsay, should be admitted for the purpose of the plaintiff establishing that the defendant has conceded to Y. And so for all these reasons, we ask the court to reverse. Thank you, Your Honor.
Any further questions? Thank you, Ms. Jones. Thank you to all counsel. The case has been submitted, and the court will take a brief recess.
All rise.